Okay, ladies and gentlemen, if everyone would take their seats, we'll get started today. Okay. Good afternoon, ladies and gentlemen. The Metropolitan Board of Zoning Appeals is now in session for its regularly scheduled meeting of July 3rd, 2014. I'm Joey Hargis, and I'll be presenting the cases for review in today's public hearing. I would ask at this time if everyone please either silence or turn off their cell phones so as not to disrupt today's meeting. We'd appreciate it. The procedure will be to introduce the case record as the Codes Department has it, and we'll do that on the wall here by means of a PowerPoint presentation. We'll present any maps, photographs for today's cases, as well as any letters we've received in support or opposition to a case. At the conclusion of my presentation, the applicant will come first, along with any persons in support, to the table there in front of you. And if there is opposition present to a case, the board will then hear from those parties opposed. After the opposition speaks, the appellant does have a period for rebuttal. The board in their rules provides applicants in cases without opposition 10 minutes to present their case to the board. To the right of where you're sitting, right beside Ms. Wolfter over there, is a clock that will keep track of your time. The clock will run on testimony. We'll stop for any questions and answers that the board members may pose to potential witnesses in front of us. It should be noted that if the appellant wishes to save some of their 15 minutes for rebuttal, be sure to do that, and we'll let you guys handle the time that's there. The zoning code does require that these proceedings be taped. It is imperative anyone wishing to address this board to please come forward, have a seat at the table, identify yourself, and make your presentation. Should be noted that it's found if anyone's presented false or misleading testimony to this board that may have affected this board's decision, any approval can be revoked at a later date by means of a show cause hearing. The board will go through all cases set for public hearing today, and after each case, the board will then discuss and then vote on the case. The code requires that 4 members of this 7-member board be present to constitute a quorum. The code also requires 4 affirmative votes to grant your application. So in the event there are only 4 members present and you do not have 4 affirmative votes, your application will be re-advertised for the next available public hearing, which will be August the 21st. In the event that 5 or more members were present and there's still not 4 affirmative votes on your case will remain on the board's agenda for the next 30 days. Actually, in that case, we will not have a meeting in the next 30 days, Mr. Chairman. So in the event we have any of the new cases today, have 5 or more members present, and we still have failure to have 4 affirmative votes, their case will be deemed denied by operation of law. Any applicant or aggrieved property owner may request a rehearing within 60 days of this public hearing. Further, any applicant or aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within that same 60-day period. But once the 60 days has elapsed, the board's decision is final. No further action can be taken. If you're an applicant and your case is granted today, it is necessary for you to come and pick up the permit for which you've applied. It should be noted that you have 2 years to obtain such permit for this board's approval to remain valid. Mr. Chairman, I submit that all cases were filed in proper order on today's agenda. All notices to landowners were sent, affected property owners were sent by first-class mail within 300 feet as required by the code, and a legal ad was published in the Tennessean. But before we begin, I do have a couple preliminary announcements. Any parties present here for case 2014-38 on the front of our page? It was a case that was deferred from the last hearing. The case has been withdrawn by the applicant. She no longer seeks to use the property for what she was proposing to use it for, and has withdrawn her case. So case 38 will not be heard today. That case is withdrawn. And Mr. Chairman, I do have one other preliminary announcement, but I'd like to go through our consent agenda first, since I have all 5 of you present and available for that. The board does have a consent agenda, and prior to today's record, a board member reviews the cases in today's hearing, and if they feel that the testimony in this case would not alter the material facts as submitted, they recommend the case to the remainder of the board for approval. I'll now enter into the cases, all those that have been recommended for consent. If there's anyone here in opposition to a case, please raise your hand from any of the case numbers that I called today, and we'll hear the case on its regular order. The only case I have on consent, recommended for consent by Chairman Whitson, is case 2014-62. Mr. Ryan Talbert is the appellant, JJB Properties LLC owner at 2118 Hayes Street, requesting a variance and rear setback in ORI to construct a new single-family townhome. Are any parties present opposed to case 62? Okay, Mr. Chairman, seeing none, this hardship in this case is the shallowness of the lot necessitates the need for variance. Case 62 is recommended for consent by Mr. Whitson.
Okay, we have a motion in favor of the consent agenda. Is there a second?
Second.
Got a motion, got a second. All in favor?
Aye.
Any opposed? Passes.
Okay, if you're here for case 62, your case has been granted. You're free to go. Be sure to follow up with the Codes Department beginning on Monday morning and follow up with them on attaining your permit. All right. And Mr. Chairman, other preliminary announcements, again, just repeating, case 38 will not be heard today. It's withdrawn by the applicant. You do have, I'm in receipt, and I guess I asked at this time, Ms. Chappell, I have a case that's rolled over from last time. Have you watched or any of the record or are able to participate in?
I have not.
Okay. I'll ask you if you don't mind, if you'll depart the room for a moment, I'll come get you once the board's dispensed with the business on that. And those that are here, members who did not participate in the case are ineligible to stay in the room for cases that are left over from the prior hearing. So, as Ms. Chappell departs to our soundproof booth, I always like those from game shows. We are in receipt of a letter from Mr. Peter Curry. Mr. Chairman, I've submitted it to all the members present that participated in this case. All four of you are eligible to act and discuss on the letter that's before you. You also have accompanying that a second letter by opposing counsel in that, and I'll turn it over to you all to discuss.
I would make a motion that we hear both sides' legal arguments as to why we should reopen the public hearing or should not reopen the public hearing. But it's a two-step process. First, we hear their legal arguments as to why we would, and then if we vote in favor of reopening it, then we can reopen the public hearing. Does that make sense?
Yes, I would be in favor of that as long as they stick to the legal arguments on why we should reopen or not reopen this case.
And I would be in favor if we limit it to 5 minutes each, no rebuttal.
That's fine. Okay. So we've got a motion to hear legal arguments as to whether we should reopen the public hearing, and each side is limited to 5 minutes. We got a second? All in favor? Any opposed? Passes. I believe we'll start with Mr. Curry because he represents the appellants.
Mr. Curry, before you come in, just for record purposes, this deals with case 2014-46, 2305 Sterling Road. That case is not in our printed agenda for record purposes. It was continued from the last hearing on a tie vote, and the tie vote currently stands. And then, Mr. Curry, I'll turn it over.
Very brief. The reason I wanted to have an opportunity to appear today is because I reviewed the YouTube tape, and it was apparent to me that several, if not most of the members, had some questions about what is the standard. You discussed that for at least 30 or 40 minutes. The case that seemed to carry the day was submitted by Mr. Henry, and that was that Hiawassee case, if you remember that. And the Hiawassee case had to do with commercial property, a mobile home park. And the question there was the application of the state grandfathering statute, not Metro's. And of course, in that state statute, they use the word operation because it's a business, and the business must have been operating. There is a case which, if you took this case right here, it's the Court of Appeals, and changed the names at the top. Is there a problem?
Good.
You know, we're here to talk about why we should hear this again, not the facts of your argument if you did hear it again. And so what we want to know is why we should, since your people you represented had their hearing in front of us
Yes.
and presented their case, albeit without counsel, why should we go against our established rules and allow you to rehear this case?
I'm sorry, I misunderstood. I understood someone to say, hear just the legal argument, is what I understood.
That is actually what I said, but I think it's the legal argument as to why we would reopen the public hearing, because just under our rules, we close the public hearing, then it takes
I'll get directly to that.
Okay,
Under
thank
your rules, the parties are supposed to submit, I think, 5 days ahead, the documents and so on in support of their position. That was not done in this case. You violated your rules. You allowed the owner and Mr. Henry to come in here the day of the hearing and present a letter. Maybe it was the day before, but you didn't see it till the day of the hearing, from the property owner, the former owner, testifying that she had no intent to abandon it. That violated your rules. You allowed Mr. Henry to present to you a case which is inapplicable the day of the hearing. That violated your rules. But let's just talk about fairness. These people come up here, they have no idea there's going to be a lawyer here, because they've looked and seen, well, nothing's been presented, so we'll just go in there and argue our case. Well, then they ran into a lawyer. This case is on all fours. Exactly the same facts, except this was a triplex and not a duplex. And the courts, the property owner took the position that she had no intent to abandon, she had meters, she had repaired the property, et cetera. It was even a grandmother that died, and the family estate sold it. It's on all fours, and it points out that it is not incumbent to prove an intent to abandon. They say absolutely not, that is not the standard under their saving statute down in Red Bank, which is similar to ours, except it's 100 days. And they said you look to use, not intent. I mean, this case is exactly the same facts as we have here. Just change the names and make it a triplex instead of a duplex. This case answers the three gentlemen who had questions about what's the standard. There's the answer, black and white. This case is not only on all fours, it's on all five. And I would ask that and I'll conclude, I would request that the board, in view of proceeding under an erroneous standard at their last meeting, that they reopen the hearing and take into consideration what the true standard is in Tennessee under our laws.
Mr. Curry, I'm assuming the appellants are your client. I'll refer to the appellants. I was going to say your client, but not only did they have a chance to present their case, but they also uniquely to the other parties had a rebuttal period to refute or rebut all the testimony and given. And not only that, they also had the option of deferring the case before it was voted on. The reason that, or a reason that I suppose that you're making this request is that because of our rules, we did vote, and that's what set the 30-day clock ticking. And I don't know about the rest of the members, but if the main concern is, they ran into a lawyer, wow, we weren't prepared for this. At any point, they could have said, hey, we weren't expecting this. Can we defer to the next meeting?
You have adequately described the situation. They showed up and there was a lawyer here and they weren't.
But they, at any point in the hearing, no one raised that concern that they were outgunned or.
Well, I can only say maybe they didn't realize they were until you all voted. That's appeared to be the most obvious answer. But as far as deferring, I think there was a stop work order posted in this case, and I don't mean to speak to the board, but I'm not sure you would have deferred it till the next meeting and left the developer subject to a stop work order. But that's neither here nor there. That didn't arise. That's just speculation. But is it possible, with all the rules, that I can submit this case to the board?
Chairman, I would wait to hear opposing counsel.
I was about to
consider that.
I was about to say, I think that would be part of the reopening of the public hearing if we did it. And so I think we need to hear from the other side to determine whether we're going to reopen the public hearing.
I'm sure Mr. Henry has a view on that. Last thing, we are not requesting a rehearing. Okay, so all the response with regard to us not following the rules as to a rehearing, we're not here for a rehearing. Thank you.
Mr. Chairman, members of the board, Sean Henry on behalf of the property owner. I think I'll first refer to Mr. Curry's letter to you where he states that a discussion by the appellants, they were not prepared to participate in this discussion because of their lack of counsel. And that's essentially what you're being asked today. This appeal was filed on May 8, and it was heard on June 19. That's 6 weeks. So there was a 6-week time period in which the appellants could have sought to obtain counsel or retain counsel, and there was no indication that they've tried to do that, no indication during the hearing on June 19 that they've attempted to get counsel and couldn't get counsel, or that they had solicited legal advice and was unable to present that legal advice to you on June 19. So just looking at your rules, and that's all we're asking you to do here today, is really just to follow the rules that this Board of Zoning Appeals has adopted. And if I may, when testimony is given both by the appellant and the opponent, there's a time frame for each to do that. And under rule number 8, paragraph L, it talks about time limits in your testimony, and if the petitioner or the appellant finds themselves running out of time and can't adequately make their case, they can ask this board for more time, for additional time, and they can put forth extenuating circumstances under your rule that exists that would prevent them from being able to complete their case record in the allotted time. None of that occurred back on June 19, 2 weeks ago. The appellants made their case. They were allowed to rebut. They were allowed to rebut by bringing additional neighbors to the table, and there was, I recall, one on each side who also addressed the board. And at no time during any of that did they say, we have more information, we have someone else that needs to speak, they're not here, can you let more people speak? In fact, as I recall, Chairman Whitson asked for a show of hands in the audience to see who in the audience was here on behalf of the appellants, and there were a significant number of people who raised their hand. And if I recall correctly, the question was asked, is there anything more to your presentation? And no one had anything more to offer. So the very last item under your Rule 8, item L, says that upon the conclusion of all of the testimony and the evidence, the public hearing will be closed, and it was in this case, and no further evidence may be admitted except as the board may permit on motion. This begins by saying at the conclusion of testimony and evidence, but then it says this board could accept evidence, not additional testimony, but this board under that rule could accept on a motion additional evidence. So I suppose this board could move to accept the writing that is an opinion that Mr. Curry is proffering. But the kind of evidence I think that's being contemplated there, and it's not testimony, but it's things that may have been said during the public hearing that you all want to see on paper, where someone says we have evidence of X and the public hearing is closed and the board members have their discussion, and a board member moves that we should accept whatever that reference was in writing to that document. Let's accept that document into our record for our review before we vote on this, because we presently don't see that in our record. I think that's exactly the intent of that provision in your own rules. So it would allow for new evidence, and I think that's written evidence, but it certainly wouldn't allow for additional testimony, because otherwise you get to the point of asking for a rehearing, and the whole process of coming back before you and putting on a whole new realm of evidence. So respectfully, we disagree that there's any new evidence put forth here to justify something new and different that you didn't hear 2 weeks ago. If Mr. Curry had just stated to you that there's something we forgot, there's something that my clients forgot to give you, there's something that our clients had in evidence in the room 2 weeks ago in their satchel or in their pocket, and they simply failed to provide that to you, and it's going to be important, it's going to be material in your decision here, then I would say, under your rules, any one of you could move to allow that document into evidence and consider it. But that's not been offered here. That's not been offered at all. So this is an opportunity for the appellants to have a second bite at the apple, which is unfair to my client.
Time, Mr. Henry.
Thank you.
Mr. Henry, what would be the harm, what would be at risk or harmed if we did reopen the hearing or allowed additional submission?
The appeal that was filed on May 8 included a stop work order that was issued that very day. We are now 8 weeks later. Every month, my client is expending $5,000 in carrying costs on this construction project. So we are now $10,000 in the hole without any further construction being taken. As we move forward, those costs are just going to go up. And that doesn't count as legal fees and our opportunity to defend the action here before you. So the risk is a monetary risk that my client continues to continue to carry as a result of the delays here.
Would you agree that that the board is allowed to suspend or change their rules?
I would agree with that, and it's Rule 17, and it says that under extraordinary cases, this board may amend or waive or modify its rules of procedure. So you must first find that this is an extraordinary case, that extenuating circumstances have been offered to you, and there needs to be reasons by the board to justify any waiver or modification of your rule. And I just haven't seen that presented to you here.
Let me ask you, Mr. Henry, in light of the fact that this board didn't come to a consensus on that vote, it's effectively held up or whatever, am I correct? Clear me up.
No adjudication by the board has not adjudicated the matter because there was a vote of 3-2. Thus, the appellant received fewer than the requisite 4 votes. No action has been taken. As you know, with all cases where there's no formal adjudication made by the board, the case stays open for 30 days. We're still within that window.
So let me ask a further question, I guess, of counsel. In light of that, the position of Mr. Henry that they're being further hurt financially because there was no decision, does that fact that if this panel did not reopen or whatever, would that make any bearing on that? Does that? That's where I'm lost, you know.
I wouldn't be a lawyer if I didn't say it depends.
Thank
so,
you, sir.
Mr. King, it depends. And what it depends on is if the board were to choose to make the motion, second the motion, pass the motion to reopen the hearing. If the board were to determine that the matter needed to be reposted for public hearing and renoticed, then that would push it to the next meeting, which, as you know, because of unusual circumstances with regard to our scheduling and availability of facilities, is all the way out until August the 21st. So then, the answer to your question, does the financial-based argument matter? I think you would probably say yes. If, however, the board chose to reopen the public hearing, chose to go ahead and have that public hearing today, proceed and vote and adjudicate the matter accordingly, maybe, maybe not. Perhaps no, it would be the answer to your question. But while I would not deign to speak for either of the attorneys who are representing their clients today, I certainly understood that argument to be there has been time expended throughout the process, and each day that passes probably does more of that. Now, to whatever weight that would carry with the board, it's for you to determine.
I wonder if we have any more questions for Mr. Henry for the remaining discussion is.
I don't have a question for Mr. Henry. I have a question for John.
No, I didn't want to stop it. I just didn't know if we wanted to move into the discussion period and just.
That's fine by me. Any other questions? Okay.
I just don't want there to be any confusion. They're not asking for a rehearing. They're simply asking to offer you more evidence, and he's offered that on here today. Thank you.
Which gets to my question. If we were to reopen the public hearing, the only way we could get Cindy involved in this is if we completely redid the public hearing, right? Represented.
Start from square one.
Start from square one. So it would just be the four of us that would hear this.
Well, because David's not here.
Because David's not here.
So one of the, what was the vote?
It was 3-2.
And who were the two? Joey, who were the two?
The members voting to uphold administrator, Mr. Ewing, Mr. Harper, and Mr. Whitson. Mr. King voted against. Mr. Taylor voted against.
So one possible outcome is that we open it to some degree, allow evidence or testimony, and Mr. King could change his vote.
Well, Mr. King could change his vote anyway.
Correct. I'm just saying that's a possibility. If we're going down if we're to opine what is the possible outcome. I'm curious to know procedurally what do we do with the vote that's on the table? Because that's what got me to somebody could change their vote, of course, with or without hearing this, but how do we vote for something that
under your rules, Mr. Taylor's vote goes from being no to being absent. He essentially withdraws from the case because, remember, we had the original hearing.
Right.
Within 30 days, there has to be a decision.
But do we abandon the original vote?
No, the original vote would still stand.
So it would really come down to convincing Mr. King to change his vote,
or any of the other three could also
or not to change their vote.
Everyone can change their vote.
Right.
That's right.
Under our rules.
Okay.
The only way for Ms. Chappell or Ms. Jones to be eligible today would be to watch the entire record from prior,
But
plus
Joey,
the record currently being created.
walk us through this procedure again. Obviously, you started this meeting by talking about getting 4 votes for cases. So
Yep.
if 4 votes are not gotten today on either side, what happens?
This case, the default position is the zoning administrator is upheld. His decision to grant the permit stands.
And as a corollary to that, it'll take 4 votes to determine to reopen the public hearing, correct? It will. Okay.
So I'm also curious about the clocks that are running at the moment. It seems that once we vote to open the case, then the clock gets reset for all potential activity. Is that correct? Yeah.
That's my understanding, Joey, that's practice of the board, your experience.
We can't open it and say, we were wrong to do this, so you're still on the same clock.
And Joey, if we, for whatever reason, decided to reopen this case and hear additional testimony, and once again, I know I asked this before.
Sure.
No one gets 4 votes. This is just defeated then.
I think, well, in this case, I need to look. I mean, if Mr., and that's something, John, I need to ask you, if Mr. Taylor truly, by not being here, his vote, they decide to proceed, they hear new testimony, Mr. Taylor essentially becomes an absent at that point. Now I only have 4 members here in the case, and I don't get 4 votes. We re-advertise the case for the next available public hearing, which will be August 21st.
But voting on a motion to hear this evidence in no way affects any of that.
No.
Unless, of course, we vote to open the case.
Correct.
So John Michael, if we open the case again and nobody gets 4 votes, what happens?
That goes under our rules of procedure under case decisions in the event that the appellant fails to receive 4 affirmative votes within this 30-day window. The case is deemed denied by operation of law. So that's the effect of
And
it.
since we don't have a case at the next meeting until August 20-something, what happens?
The clock will expire, and the effect of not receiving 4 affirmative votes for the appellant today would be that the case would eventually be denied by operation of law. Or the appeal would be denied, I should say.
Stop work order would be lifted.
I'd have to let the staff speak to that. I don't know the procedures on how they lift those.
I mean, does that,
We would.
to the end of that clock,
Well, that's not for us to decide.
But that would be the evacuation. It's not what was lifted in that scenario.
These are just my thoughts. I am exceptionally sympathetic to the appellants because having been in their place at one point in my life, you really almost don't realize you need an attorney, but the zoning laws themselves are becoming so complicated, and then you have the interplay between state law and local law, and I'm an attorney, and so this is not a PSA announcement for hire attorneys, but to a certain extent it is. I mean, because it is exceptionally complicated, and in most instances, it would behoove you to have an attorney. So I'm exceptionally sympathetic to them. I wish they had had counsel at the meeting as well. Having said that, I'm not sure I think it's a just result, because what we're going to do from a policy standpoint is potentially come take your bite at the apple and then show up at the next meeting and say, dadgum, I wish I'd had an attorney. So those are just my thoughts for what it's worth.
And I tend to agree, except the question in my mind is, I thought to have a rehearing, you had to introduce new testimony or something, new evidence or whatever that you didn't hear in the original go-around, that could perhaps sway everybody's vote. Am I right or wrong?
To be technical, they're not asking for a rehearing. They're asking us to make the extraordinary move of, after the vote, open the public hearing again.
I didn't get it that way, but I'm a little slow today anyway.
Well, no. I mean, it was because I initially, when I first got Mr. Curry's letter, I went and read the rehearing out of our rules.
Mr. Whitson is right, but the fact might be, if you kind of open this up again and people start talking again, no, it's not a new hearing from square one, but, they get to kind of talk and the other side gets to rebut, and, but you said new evidence, and that's kind of where I stand too. He has case law, and I tend to agree with what Mr. Henry said, that I think when our code talked about new evidence, I'm not sure if they were talking about just a case, a legal case.
new evidence versus a better argument.
Because the code also talks about, and what Mr. Henry has given us in his letter today, no such request to grant a rehearing, I know we're not talking about this, shall be considered unless new evidence is submitted which could not have been reasonably presented at the previous hearing. So if some kind of, here's somebody that really knows what went on, or we have pictures or video or something like that, that's kind of, hey, if you had known this, you might have acted differently, not necessarily some case law that lawyers can argue about.
Yes, that's what I was leading to, because I read that and understood. Are we talking about a rehearing with only if we have new?
No, we're not talking about a rehearing,
Okay.
but, the standard of kind of reopening this, or, we get to determine whether that side has met the burden to have us to hear some new evidence that was not presented at their case last meeting.
I would propose, I guess the way I'm looking, I'm not necessarily proposing that we adopt the standard, but I tend to look at it, from a process point of view. Can anything that be introduced or at this point fix something that could, at this vantage point in hindsight, be considered, oh, well, that was unfair. If only we had known that. And I also think about, sort of from the next level, that a chancellor looking down on us and going, why would you suspend your rules or change your rules in this case? And I don't see a good reason. It's unfortunate, but the the burden is upon the appellant, and I think they've had a sufficient bite at the apple. I don't think anything has been denied them, but by the action of this board.
I'm also going to point out, because I'm a legal standards type of guy, but I'm also kind of an equity type of guy. And one thing I do want to bring up, because I couldn't remember it myself till I just asked John, we didn't simply rely on Mr. Henry's legal standing. We also asked our own attorney what we should be following. And so, again, I wish they'd had an attorney. I really do, because I think it would have, advocacy is good for everybody. But it's not as if we took Mr. Henry's view in toto because he was the only lawyer in the room. We did ask John as well. So I throw that in just for.
And I don't appear as I'm advocating, gee, everybody better have an attorney, or they didn't have one, so they should get another shot at it. I'm not advocating that at all, because I admire Mr. Henry, and I'd hate to go against him. It'd be like you dueling with an unarmed opponent, dealing with me, but I just simply trying to get reason for everybody, and that's, I thought, again, maybe erroneously, that we talked about if new evidence had been found, I'd be all for hearing new evidence. May change my vote, that was my only purpose for that question, so.
No, and believe me, I'm absolutely, because I am actively telling people to get attorneys, because I think if you've got a standard, call it a variance case, where do you have a narrow lot, and then the public can intuitively do it on their own. But when there's active opposition on both sides, I think you're well served to have an attorney. And that sounds like a guy trying to enable more attorneys to get hired, but that's really not my point. It's just too complicated now. The zoning laws have gotten exceptionally complicated. Does anyone have a motion? Well, if they don't, then I'm going to make a motion. I'm going to make a motion that we deny the request to reopen the public hearing for the simple reason that I think they had their opportunity to hire counsel, and it's almost just not fair to the process or to us to reopen it at this point, notwithstanding my sympathies.
Before we vote, if we reopen the public hearing, right, we're entitled to ask questions for that? Mm-hmm. And where are our limitations in the specific area? Are we, I guess our counsel, maybe you can tell me that. What are our limitations if we vote to reopen the public hearing? I guess that happens today? Is that what we're talking about?
If you reopen the public hearing, the board could determine that either way, but you could typically hear it today in most instances. In the event that you chose to reopen the public hearing, you probably could encourage speakers to focus on X, Y, or Z factors that the board deemed most appropriate. Even if you don't reopen, I think the practice of the board in the past has been that they were occasionally willing to ask questions of representatives or parties or appellants, as the case may have it, to gain some specific pieces of information rather than just throwing it wide open for X number of minutes for whatever testimony folks wanted to give. Hope that's helpful.
Okay.
Okay, so we have a motion, we have a second. All in favor?
Aye.
Opposed? I don't blame you in the least.
I would favor reopen that public hearing, but I'm outvoted 3-1, so.
Okay.
I guess this is not like a case per se, it's just a procedural thing, so. That doesn't take a 4 votes. That doesn't take a 4 vote.
Actually, don't our rules say something about that someone would have to move to open the case?
Move to open.
I think that would require 4 votes.
Under Rule 8. Rule 8L out of our procedural rules guides. Upon conclusion of the testimony, public hearing will be closed. No further evidence may be admitted except as the board may permit on motion. At this point, there has been no motion to reopen by the board. In fact, there's been some sort of a motion with some sort of a vote to not reopen. So only if the board moves and then approves the reopening would it be reopened.
So I don't, unless somebody says there, I don't think we have to have 4 votes not to do something. That was more of a internal operation.
Well, there's a question buried. If we've had a request and we don't get 4, I'd cut me off too. But if we have a request and we don't get 4, then the request fails, and aren't we back where we were, which is a 3-2 vote for the remainder of the 30 days?
Well, it could be through, because this vote is only on this question here of whether to reopen, so it couldn't go back to a 3-2 vote. It'd have to be
Well, no action. We're voting to take no action.
Yeah, and I guess his argument is you don't know what they'll say, and maybe someone's motion will be changed.
That's all I'm saying. I don't deny us the right. Find out, well, gee, if I'd known that, I might not have voted that way, you know.
But under this circumstance, I think Mr. Henry used the word extraordinary. I'm not sure if that's, maybe it is in the code. Where do you draw the line when someone basically doesn't have 4 votes and say, well, I will have more information and I want another day to argue this case?
Good point.
Okay. Mr. Chairman, so under our rules, Rule 9C, case 2014-46, as the record reflects, I asked Ms. Chappell as she reviewed the record. She said she had not. That being, there will not be another hearing within 30 days of the prior hearing. Under Rule 9C, this case is deemed denied by operation of law. 9C stating in the event 5 or more members present failure to receive 4 affirmative votes within 30 days of the public hearing, the case shall be deemed denied by operation of law. So case 46 is the appellant's request denied. The order will be entered that the under Rule 9C, that position, the zoning administrator will be upheld in the case. So that will dispense with that case. I'll get Ms. Chappell back in, and we'll hear case 58. If I can have just a brief recess, please, Mr. Chairman. Thank you. Okay, ladies and gentlemen, the last case on today's agenda is case 2014-58. The applicant's present. Mr. Stepper, are you here? All right. Any other parties here with you, sir? On your behalf? Oh, I'm sorry. On the appellant's behalf. Okay. All right. Sir, if you'll come forward to the table, I got to go through a couple things, and I'll turn it over to you for your time. Let me bring up the drawings. Okay, as I said, this case is case 2014-58. Mr. Ron Sepper, appellant Sabrina Shoulders, owner of the property at 2326 Nolensville Pike, requesting a variance for the Nolensville Road street setback, and I'll go over that, and a special exception for Austin Avenue and Peachtree Street setbacks in CS to construct a new 4,990 square foot, 1-story retail building, referred to the board under section 17-12035 and 17-12035 section D1. The appellant has alleged the board would have jurisdiction under section 1740-180 items B and C. And before I begin, parties present opposed to the case, show of hands please, that wish to speak. All right, you two gentlemen just hanging out with us today? All right. Each side will have 15 minutes to present. Ron, I'll go through my portion first, and I'll turn it over to you guys. The subject property is located here at the intersections of Peachtree, Austin Avenue, and Nolensville Pike, which you see here. The property is surrounded in red on the drawing. This is a aerial photograph, recent, showing the subject property. It comes before you. You guys are familiar with special exception requests for setbacks. It's actually technically a variance along Nolensville Pike. The code requires that this building be placed on the front property line of Nolensville Pike. So he's asking to be back further than he's required to be by the code. So under our ordinance, is actually technically a variance from that standard, rather than the special exception where folks are trying to get closer to the property line. In his case, he's wanting to be away from Knowles Road. The code actually requires him to be up on Knowles Road itself, with parking at the rear. This is the site plan that he submitted on the case, showing the proposed building locations being essentially at the Austin Street setback and approximately a few feet off of Peachtree here on the south. These would be his buildings, parking area out front, driveway that exist on the current site now, and an elevation he submitted to you all for that. This case has actually been before the board a couple times. It was first approved in 2008 under a very similar site plan layout. Mr. Sepper's 2 years ran. He reapplied for additional permit. I think if history, my recollection recalls, we deferred action. He ultimately withdrew his case and then resubmitted in November of last year, and withdrew again and resubmitted for this hearing. So waited his requisite 6 month periods in there to not be stuck filing with prejudice. So this is the elevation that we see. This is the subject property. My view from Knowlesville Pike is just behind me. I-440 on-ramp is just to the north of the subject property, which you see in the upper right photograph. This is the applicant's property, the 440 east on-ramp there at Knowlesville Pike. These two views on the bottom, upper left and bottom right, are views along Austin Street. This is at the rear of the property. The subject property does slope off from the height area. This area, which you see here, is elevated above the Austin Street location. So his proposed setback would be along Austin, with some proposed parking coming in off of Austin. As you'll notice, the subject site, again, this is where I was on the first photograph shooting at the building. The topography of the lot slopes is fairly flat across here, but as a whole is much higher. This is at the intersection of Peachtree and Austin, looking toward Knowlesville Pike. You see the slope of the property there. And then that view in the upper left photograph would be, I just panned that camera slightly to the right to show the view down Austin.
Hey, Joey, can I ask a question? Just from the drawing, it looks like it would go all the way up to Austin, but for a sidewalk. Is that correct?
That's correct.
Okay.
The code would require him to build sidewalks on Peachtree and Austin, running the full length of his property, and he's proposing to construct those as required by the code.
So, again, there's going to have to be a real grade adjustment, right? I mean,
as part of the permitting process, the stormwater grading folks will be involved pretty heavily on this side. There's topographic change from Austin to the slab or the flat part of this property where the building in this area, when you see in the photographs here, exists, where my cursor is moving.
okay, I'm just trying to figure out if my eyes are lying to me. You're either going to need to bring in a lot of dirt or take away a lot of dirt, right?
Right. There's going to need to be some grading, especially along this side. Now, this is at the Austin site, and you see the electrical poles and such. So the property line is just inside that.
Okay.
Joey,
Sure.
could you go back to the aerial?
Mm-hmm.
So what's called an alley on the drawing obviously is a dead-end alley.
It is. It's what we call in our business a paper alley. It exists only on the maps. It is, the right-of-way is there. It's not a functioning or existing alley. But there is a metro right-of-way along the north property line.
But it stops before the on-ramp.
It actually, it only goes in for a small portion, maybe 10 feet off of Austin, and it stops altogether.
Okay.
But the alley itself on the maps runs all the way to approximately the 440 on-ramp here. But the portion that actually exists is about to this point where my cursor is.
Okay.
In real life. None of this exists today.
Okay.
Joey, did we receive a letter or an email from Councilman Tenpenny about this?
Let's see here. His folder.
Basically stating his either support or opposition or anything else we should consider.
Look it through, Mr. Ewing. I do not have a letter from the council member in either direction.
Okay, yeah, I didn't see a letter either, and I'll ask the
As of this morning.
opposition if they could shed light on any.
If it came, it would have had to come after about our 11:30 printing.
Okay, but you haven't received anything.
No, sir.
Thank you.
I do have a copy, and because this is a special exception, I do have a copy of a letter Mr. Sepper sent to the neighbors. Our office did provide him with a mail list to hold public hearing.
When was that held? Because it seems like there was talk about having one last year.
His letter, well, remember, he came before this board back in September or October and withdrew the case and refiled. So when he refiled, we made him hold another. And the date of the letter he's invited folks was June 30th of this,
Okay.
At 6 p.m. So we have that in the record. With that, sir, you do have comments from the planning department, and Public Works says essentially that they will look at it during the permitting process. Sir, I'll turn it over to you. You'll have 15 minutes to present your case to the board, and you'll also have a period for rebuttal after the opposition speaks, should you wish to. All right.
Thank you so much, Mr. Chairman, and all the members give me this opportunity. I would like to mention, as Joey already mentioned it, that this project was already approved back in 2008, and the main reason never pursued that because of the economy turned down. I'm going to be very brief and just get right on the point. Understand the neighborhood got some kind of objection about the traffic. Understand that some people are not happy with having a cash place and some other businesses there. But the problem is, no matter what you do, you're going to have some kind of objection about any project. The best way is have a discussion and improve it and do the best I possibly could. I try to hold a community meeting and have a traffic study. Mr. Tenpenny requested, never been done, so that's why we never had that community meeting.
You're saying you never had a community meeting about this?
I had the community meeting, but I had it in we had a plan to have a committee meeting in a special session that in some place that we can discuss the traffic issue. But as far as having a community meeting right on the job site, which I had it last Monday.
Okay, you met, you just didn't meet on the site.
Yes.
Okay, that's fine. Where was the meeting and how many people showed up?
Nobody showed up.
Well, you were there though.
I was there myself, and I waited for 30 minutes.
Was the council person there?
There were council person. We had a conversation, and he asked me about it and said, no, nobody showed up.
Okay.
But I had a few calls. The biggest problem I have there, that traffic, is going to be there whether with the code that I can build a building regardless. If I can build a building with no problem. But my issue is, in order to build a building which fit the neighborhood and be nicer and be more practical and not having any hardship, I have to sit back. Otherwise, I have to build that building against the fence right on 440 on Nolan's Road. That's the biggest hardship I have there. And of course, we had for last 2-3 years, since the parking lot is on the front, I had almost close to 15 break-in that people broke in from the back of the building. I find the bottles of beer, all kind of glasses there that people get in the back of the building doing the drugs. But the biggest problem is to have it building on the back part that is more visible, nicer, and practical without having any hardship. And of course, as you saw it on the slideshow, that there's a lot of NES got a wiring there, a lot of easement around, that I'm pretty much limited to where to build it, how to build it. And I'm asking this committee to go with my variance and help me out to do a nicer and better building for this community.
Did you say there was, is there an NES easement on the Nolensville Road side?
Well, for fact, I don't know it, but I see the wire all the way around the building. You
Joey,
see the pole in the back?
This is the transmission line over. It is on his side of Nolensville Pike.
Okay, there's one there, right there, also on the right that corner. Yes.
Joey, I don't know if the Metro map has the, you know, if it has the, excuse me, the NES easements, or just shows the lines?
It just shows the line itself that's there.
Okay.
Joey, he mentioned that we had this case in 2008 and we approved it. Did we approve this case, the exact same submittal, what he has proposed today?
It was a little bit different. Submittal was actually larger, if I recall. Let's see if I've got the database goes back quite that far.
But do you remember it being approved? I can't really.
I do. Wait me 1 second here.
While Joey's pulling that up.
Yes, yeah, that was granted in March of '09.
Okay, so what was granted?
The one-story retail building. His original request was $10,175. This request is $4,900. His first request, if I recall, had some condos above it. It was 2 levels. I think much too large. Withdrew it, refiled it as a one-story. Got approved on, as you see here. I don't have square footage attached to that one.
6-0.
Yes.
Or 5-0.
6-0.
6-0. And you seconded.
And then deferred in June and withdrawn in September of last year, and then refiled it here.
I know you've said this, and I'm too dense to have picked up on it, but it's a variance on the front setback. And on what about the side and the back?
The other 2 streets on the south, this street here, Peachtree, is a special exception to locate closer to the road
Right.
than is allowed. And along on Austin, back at the rear, is proposed to be at the right of way, or just inside of whatever easements are there, as close to Austin as he could get it.
And
which is
that's
also a special exception as well.
That's a special,
Yeah.
and nothing on the alley.
The alley, nothing. The
We're
alley's
okay on the
fine.
alley.
There is no setback on the north side at all.
Okay.
So that part's okay.
Are your parking requirements covered in the surface lot? Or are you using? I know you have the potential to use parking underneath it from the drawing, but is that part of the code required parking,
No,
or are you meeting
it's not,
it on the
no.
surface lot?
No, I got parking space there to fit that building for 5,000.
Okay.
Commissioner Hart, the 17 spaces shown here comply with he has enough parking for the Now, based upon, as we tell folks when they develop these multi-tenant type buildings, based on a retail parking count, if you lease everything out to a restaurant, you might have some problems. But depending on this tenant mix, they have to be careful on the types of tenants they rent to as they go along. And we do keep track of that as it goes. And we have instances where some shopping centers, they've rented it to 2 restaurants, and now they've ate up all their parking, and so we end up the rest of it not issuing permits on. So that's something that applicant will have to be careful of should this board approve his request.
Sir, can I ask you a question?
Yes.
One of the requirements of the setbacks, the special exception for setbacks is an applicant shall provide evidence to the board as provided that the proposed building setbacks shall not create an adverse impact on adjacent properties nor detract from a strong pedestrian-friendly environment. I assume you think your project does not do those things?
Yes, sir.
Okay.
I really believe if you look at the building the way it is now and the way I'm going to build it, it would be tremendous good positive effect to the neighborhood. And of course, it all depends how good a tenant, how the overall workout to become that it would be exactly the way the neighborhood wanted. And that is probably near to 0% that could happen. But with all my knowledge and experience that I've been in that neighborhood for a long, long time, I would believe that I would make that kind of potential friendly neighborhood for the people with the kind of background that my family have, church background. It would be very practical for the neighborhood.
Do we have any other questions for the applicant?
I just have one question, and because of the traffic condition there at, Peachtree, would you consider having your parking lane or your surface lot being one way, as in entry off of Peachtree and exit out the alley to? Do you see what I'm saying?
Yes, that's another plan that I have, that talking to Mr. Tenpenny, maybe we can use that space, that area, that have it one way, or at least use it as another exit in order to help the traffic out.
Mm-hmm. Okay. I'm not saying that's a condition at this point. I was just curious if that was something you.
Yes, it is. Like I said from the beginning, a lot of this stuff, I'm willing to work it out with the neighborhood, see how everything plan out, what is the best way, and what Metro can do for the neighborhood and for the building in order to be more practical and help the traffic.
Mr. Whitson asked you about this being pedestrian friendly, and I'm not sure if you've seen what the Planning Commission said about this, but they're saying this is not pedestrian friendly because of the surface parking lot and that the building is not close to Nolensville Road. Did you consider moving the building to Nolensville Road and having the parking in the rear and making this more, close to the street?
Well, moving the building to the Nolensville Road is gonna, as you see on the plan, there's rails on the Nolensville Road. That is not practical to have the building very much against that rail. And Joey knows that the last building, I have to be lined up with the last building. If I demolish that building, the last building on that area would be the one on 347 Valeria Street, which would be farther in, closer to Nolensville Road than the actual building that I have there. So if I'm gonna do it right exactly the way code wants me to, I have to move that building closer to the fence.
I've got a couple of questions because I was trying to get it from the aerial. The sidewalk that exists along Nolensville Road looks like it quits about halfway down the interstate ramp,
That's correct.
which makes perfect sense because we wouldn't want citizens walking on the interstate. And I think your testimony is also that, well, I think it's Joey's, that there's going to be a new sidewalk back on Austin.
Exactly.
Okay.
But that fence is what it has been done with federal, and it cannot be moved under no circumstance. So the sidewalk, if Joey put that, the side plan out there, okay, as you see that area, that would be some kind of right there, that would be sidewalk behind the fence.
So
That would be practical, even put the chairs, seats, or whatever out there. People can, sit down and relax and enjoy the traffic or intersection, or have a coffee there if I have some kind of coffee shop or some kind of more family type of tenants there that use that area for the community.
So in this drawing, we're assuming, or I am, that the fence is on the line that is called out with the meets and bounds.
That's correct.
But that's approximately, and you're saying that that fence is the interstate's fence.
Right.
And is the guardrail, is that yours or is that theirs?
No, it's theirs. Rails, everything is theirs, yes, sir. Right there.
Planning needs to talk to the interstate people about that, because that's not friendly.
Have we got any other questions for the applicant, or? Okay, then you've got 11 minutes and 28 seconds for rebuttal, and we'll hear from the opposition now.
I'm done.
You never know.
All right. You'll step back, please. And any other parties wish to address the board, any questions or concerns or opposition, come on forward. Sir, if you have a seat back. Okay, come on up. Anyone else wish to address the board, please feel free to come forward. I've got 2 other seats there.
All right. Thank you. My name is Seth Timms. I live at 336 Peachtree Street. It's within...
Joey, can you put that aerial map up?
Yeah.
So
It is within 300 feet
Can
of
we
the
see your
property.
house?
I think, yeah, that's it. That is
Okay.
it right there, yeah.
Where the arrow is, okay, thank you.
Yes, sir. I'm not coming up so much in opposition to the variance as just to re-raise some concerns that the neighborhood has, raised previously concerning ingress and egress from the property, which has already sort of been mentioned here. That intersection and the ingress egress to that property is problematic, to say the least. Basically you have to go over 2 lanes of traffic in order to enter into that property. You have to go over the turning lane from Peachtree onto Nolensville Road, and the right and the left turning lane, actually. When this was brought up before, it was recommended that a traffic study be done about that issue, and it was not. I assume that's because it was withdrawn, and there was no longer any there, maybe, but I think a lot of people in the neighborhood would still like for there to be a traffic study done about that issue. You have anything to add?
I'm Andy Roberts, and I'm the Vice President of the Woodbine Neighborhood Association, and I live at 214 Peachtree Street. And as far as the traffic study, I was told, I spoke with Councilman Tenpenny several times in the last couple of days, and have been told that Metro said there was no need for a traffic study, and that it was his assumption that we were going to have a community meeting, but nobody ever did anything about it. And I get here today and find out that apparently some letters were mailed out to people. I know you got one.
That's true. I did receive one. And,
I didn't get one. I know no one on the neighborhood association board was aware of any of this.
How come you didn't go to the neighborhood meeting?
I wasn't able to attend because I was working. It was held at 6 o'clock Monday, I believe, this past Monday, and I was just unable to go because of work.
It sounds like didn't
Well, I'm in the 200 block. He's in the 3, but I had no letter. I didn't know that.
Can we
this
see
is-
your house from this picture?
No, I'm further back. I'm further back this way.
But you weren't in the 300-foot notice.
No, I was not in the notice. And I know that we've requested several times with Mr. Tenpenny to have meetings with Mr. Sepfer. We're all, I think we're definitely pro redoing this property and things to help the neighborhood, but we're all really concerned about the traffic because those of us that have lived there a long time have pretty much been witness to, multiple incidents and near accidents and that kind of thing.
I'm sorry, go ahead.
You say traffic. What are your real concerns about the building as submitted on this site?
I think the parking and getting in and out of this building, the way it's submitted on site, I think is going to bring more traffic to the front of this building. And what's hard to see is if you look at that aerial shot, you can see when you turn left off Nolensville Road, Peachtree kind of dips down. It's not a flat surface, so you really can't see. When you make that left-hand turn, if there's somebody already there trying to turn left into that building parking lot across the 2 lanes of traffic, there have been several occasions where I've almost seen cars rear-ended because you're not able to see anything. And it kind of leaves everybody hanging out in the middle of busy traffic and on Nolensville too.
So I guess the concern is to increase the number of cars that could, potentially be in there is just going to exacerbate a problem that already exists. Traffic-wise, that's really, speaking for myself, that's really my main concern is in fact the traffic. I have nothing but support for him building a new building there, a nicer facility. I think that's fantastic.
And I'm the same, and I think most of our neighbors are the same as well. Everybody would like to see improvement on that property, but it needs to be the right kind of improvement that doesn't cause further problems.
Well, let me ask you 2 questions, if you don't mind. First of all, is any of y'all's objections to where the building sits on the property, or is it just increased traffic?
I don't have a real problem with where it sits. I think that...
Or would sit.
Where it would sit.
I think the biggest problem I have is people going into the parking lot from Peachtree. Because it's like Seth said, you cut across those 2 turn lanes, and when you have cars sitting like this waiting to turn, and you have somebody cutting across or trying to get out, it's just a constant source of problem. If you have a car waiting to turn into the parking lot here, other cars are just hanging out onto Nolensville Road, and it just really causes an issue.
Yeah.
And I guess my second question is, he mentioned crime behind his building. Have y'all noticed that at all, or?
I haven't noticed that personally, but I noticed there's always a lot of, junk.
There's dumping involved there. That's, I'm sure he has no control over that.
No,
but it is just, as you can see, it's sort of a dead space, if you will.
Yeah.
Kind of invites that kind of thing, people pulling up. So you'll sometimes find whatever, all manner of things.
Yeah, I think we've had some issues with maybe homeless people camping out in the green space along 440 there. And
So what would you think if the or what's shown now as an entry and exit off of Peachtree, if it were, say, exit only, like exit and right turn only out of
I
there?
think that would be better.
Yeah, I agree. I thought that if there was a way he could use the alley, like I think you suggested that earlier.
Well, at the time I was thinking more about egress more than ingress, and I'm actually now asking the opposite. If the Peachtree entry were exit only, and presumably it would only be right turn. So if you wanted to go down Peachtree, you would have to go back out the way you came in.
Right.
I think that's better, but I think Austin Street is still, it's so close to where you make that left turn and you go down that little dip, and if somebody puts their brakes on to turn right there, people turn and they end up slamming on their brakes.
You think even if there wasn't an entry there?
I think it would be better, but I think Austin Street, how close it is to Peachtree, if you have people sitting there waiting to turn, you still may have an issue with people backing up and that kind of thing.
So how do you propose people get to this property?
I don't know.
If those two
I don't
options
know.
are bad.
That's the real trick, because
Yeah.
I feel like, I don't know the history exactly, but clearly, this property was sort of grandfathered in, if you will, before 440 was built. I don't know why anyone would ever put a building right there at the headway of an on-ramp like that. It doesn't really make much sense as it stands, but it stands, and it's going to stand. So I don't know. Again, just speaking for myself, it seems like if there was some way that he could route traffic in through the back, and then maybe, as you suggest, have them exit out of the existing entrance exit.
I mean, I'm not a real estate agent, but conventional wisdom tells me that you have the businesses there and the dumping there that you have because there's no good entry and exit to the property in order to bring it up and increase everybody's property values and make the neighborhood nicer. You got to be able to use the property for something.
Absolutely.
And right now, it's getting used for what it's getting used because that's all you can do at the moment.
Mm-hmm.
So I'm just saying, there was something out on the table here. What would make this something you could, if not get behind, at least not object to?
I actually am a real estate agent, and I've looked at this so many times, and I think it's a really tough property, but I do think that having the entrance be from the alleyway, perhaps off Austin, would be a definite improvement. If people could only go, I think if people exit the parking lot onto Peachtree, the issue there would be that it would need to be no left turn. It would need to be a right turn only where you go back out onto Nolansville.
Why don't we let the lady with the children speak?
Oh, yeah. Sorry. I'm so sorry. My name's Tasha Barber. Thank you for hearing us today. I understand the variance requests because I know most of the buildings, they're wanting to have them up on Nolansville Road to make them walkable. That is not a walkable area no matter what. It's right there at an entrance ramp. I definitely wouldn't walk it. I wouldn't take my children there to walk it. So I understand his desire to put the variance on that so that they can have it back further. That makes sense. I am also concerned about the traffic. I go through there. I live on Peachtree at 101, so I'm further down. Peachtree is a main cut through for our neighborhood. People go from Nolansville to Foster to Glen Rose. It's a very highly traveled street in our neighborhood, probably one of the highest traveled, if not Foster being that. And so my concern is just, again, with the entrance and exit right there at Peachtree. I mean, I can't tell you how many times I've been going to make a right turn and people they have the green and we have a right on red from Peachtree onto Nolansville, but they just fly across because they have the green and there's no traffic coming and they can. How many times I've almost been hit going that way, and they just have no regard. Oh my goodness. So anyways, I would really love to see a traffic study done. And I know not one has been done, and I know a council member meeting has not been called that I was aware of either. I did not get a letter because I live farther away. So anyways, if there was a council meeting or a meeting with him in regards to this and a traffic study done, I'm all for improvements to that property. Trust me, we love our neighborhood and we would love to see an improvement there. It's just that entrance and exit has always been a problem. And if that gets to be a successful property and there's more traffic, it won't get any better, And I know the idea has been to have the traffic study done after the fact. That does not seem like that's going to work for me because how long am I going to have to wait for a traffic study to get done there, But what am I going to have to do then? How much am I going to have to fight to get that rectified? So I guess that's just my 2 cents on the subject.
And if the traffic study's done and they find out that
it's a terrible idea.
Ingress from the property is not going to work. It's sort of, is it not too late at that point? Then he
Right.
would have to modify his whole
And I know
situation.
he had suggested moving the stop sign back, or the stop light at Peachtree and Nolensville back farther.
Yeah, the line, sort of the obedience
And
line or whatever.
I just don't, like, you're driving blind then, like when it says go, I mean, you can't, it's a pretty steep hill. You can't just, you just got to trust that it's okay at that point to go out, you know? And it's got to be, I mean, how many feet would you say that is from where they would want to put the traffic light in?
You mean where the stop line would be?
Mm-hmm.
I don't know. It's a good, from where they would,
30 feet probably?
yeah,
Yeah,
maybe.
I'd say,
I mean, you wouldn't be able to tell anything
no.
at that point. Anyway, yeah.
Do we have any other questions for the opposition?
I'd just like to say your kids did a lot better than mine would have in this environment.
Thank you.
You can't hold Superman in and held him in.
I know, apparently not.
Okay.
Okay, I think we're back to rebuttal. Thank you very much. I think we're back to rebuttal.
Thank you.
Sir, would you?
So, to be clear on the rebuttal issues, so far who got sent the letter, public meeting, traffic study, anything else? So I'm asking this because on rebuttal we have to keep the conversation to the things that were brought up by the opposition. So did you send out letters for the public meeting that you had?
Yes, I sent a letter.
And did you use the mailing address that I guess Joy would have used for the notifications for the appeal?
Yes, I used that. Actually, the meeting, I want to have it on the building because visually you can see it better when you describe it instead of any other places. That's what my intention was. And, well, one thing I'd like to mention is that any intersection, when the lights turn red or green, you probably have noticed a lot of people come and block the intersection. You have seen it. I cannot help that. I cannot help if somebody sees that cannot go in the building and come and block that intersection. The only thing I can help is do the best, bring it more visual that people can get in and out easier. And I asked them, well, if you have any suggestion, whether the traffic study say, okay, it's gonna help or it doesn't gonna help, the situation, the potential of that building is not gonna change anything. I still can build the building against the fence or against this or against that. But the best way is that do the best with the traffic study and make their suggestion more visible. That's what I can do. But as far as if somebody don't know how to drive or somebody want to block this or block that, I mean, there's nothing I can do.
Do you know how wide your curb cut is now on Peachtree? It's not really in this picture, but it's...
It is pretty much similar what I'm planning to do, if that's what your question is. Is that the...
Well, I mean, I can't tell what's there now, but obviously what you have drawn is wider than a 25
It
foot.
is, I would say it is pretty much, it's not a big a difference.
You would be adding or cutting more curb down Peachtree.
If it is
downhill.
more, probably so than less. But I don't think it's gonna be big a difference because I don't have much of room to to cut
Right.
that curb.
Well, how would, similar to what I asked you earlier, how would you feel if the Peachtree curb cut were, if you had a, right turn only sign?
Well, I would, my suggestion would be, what I feel is, I could make that accessible to exit some traffic, whether some of this traffic, even though might come from back neighborhood, coming in and go back to the neighborhood. And instead of, that traffic would help there. But making it the only one way, is it doable? Yes, it is doable. Is it practical than just tell people, okay, you cannot back in or back out this way, or?
Right, and I don't want to design this, I'm not here to design this for you, but I would, I've seen a lot of traffic studies where you have, when there's cross-traffic issues, you might take in an odd way, you're lucky that you do have access to an alley and a second street. But I would think that there would be a suggestion that, as it's drawn now, what's on the screen, if the arrow that is exiting said right turn only, and you would still have an entry, but you would have a secondary curb, like a small island or something in there, so that only people coming on Peachtree toward Nolensville could take a right turn into the property. So it's still an entry and exit, but it would prevent people from crossing the two lanes. If they were going, is north up on this? If people were traveling off of Nolensville to the east, they couldn't take a left turn into the property there. They would have to go to Austin. Now I know that requires signage and you can't keep people from going over curbs and stuff, but is that in the realm of possibility for you?
Well, my possibility is, what is the best, how the best way you can get in and get out? Be honest with you, I don't know if from that point to come out, only one way is gonna help the traffic or not, because once the people guys stay right there and the lights turn, they're gonna get out and they can have a room there that they can line up accordingly to the traffic light and move. What I would say the best way possibly could help the situation is if they put the traffic light down on by the Austin or close to the Austin that leave enough room for that in and out exit. That would help, and nobody would block that driveway. Of course, all this stuff is assumption, and I like to see what the neighborhood wanted, what the traffic study wanted, or what is all my option in order to get the right people, right space, right building, and more practical for everybody.
What were the other issues? I think that covers it.
That's it.
So unless we have any other questions for the applicant, I'd move to close.
I have one question. How much higher is the ground where you're proposing the buildings than the street that's behind it? What is that street, Austin?
I would say about 12 feet, something 10, 12 feet.
Okay.
Okay, I'm going to, thank you, sir, unless you have
Yes, sir.
anything else to say.
Yes, sir. Thank
Okay,
you so much.
I'm going to move to close the public hearing and start discussion.
I'm very familiar with the site. Of course, we've heard this before. It's the exit off of 440 if you're going to the Nashville Zoo. It slopes down, and this is a very tricky corner, which is why I think it has had, so much talk in the neighborhood in the past. And given what has been proposed and really the lack of communication between all parties, and even the council persons really not saying he's for it, against it, and not being at the meeting. To me, I'm not sure if I have enough information to kind of approve this as it's submitted. And while normally I'm not one of these folks that say, oh, we need a traffic study for everything, I think it would be very helpful to this. I don't really see the only entrance being on the alley as being a good business viable issue, but there's got to be a way, given this lot and orientations of buildings and driveways and two streets, and that you could come up with something that makes this work. But I would rather the sides, we had someone, the vice president of a neighborhood organization was not engaged in this, obviously, because outside of 300 feet, but to me, I don't really have a lot to go on today.
Neither do I, but I absolutely don't see any advantage to not allowing the variance. I don't see any advantage at all of making the building 0 on the front. That is not, in my mind, pedestrian-friendly right-of-way right there. How many?
So you think it's bad to make them climb the interstate fence to get into the businesses?
Well, it didn't seem to work the other time. But.
And I'm not exactly sure what the policy with, and I'm assuming this would be traffic, but, I mean, if he has the curb cut now, they're going to let him put it back, I would assume. But he would still need our variance to put the building where he wants to be able to use that curb cut. But I agree with Dick. I don't. It's not this project, or the siting of this building that makes it unfriendly for pedestrians. It's TDOT. That horse has left the stable, not to return.
In fact, I'll go as far as to, I think the orientation proposed is going to solve other problems. It's going to make it pedestrian friendly on the back. It's going to get rid of the green space that's attracting crime. And it's hard for me to see any pedestrian friendly in front. Now, I am very sympathetic to the neighbors on the traffic. And if one of the architects can come up with a great idea on traffic, I'd love it. But as far as the variance goes, it seems like a very logical way to set the property up.
Well, if we were to approve it without some condition, potentially he would do what he's got drawn here as far as the egress and ingress. And so I don't know if we want to get into the business of saying, proof, but here's the condition. You can't use that as the Peachtree entry as an entry that would have a left-hand entrance. It can only be a right turn ingress and a right turn egress at the Peachtree entrance.
It sort of sounds like we might vote today, and the only reason I bring that up is because we have this unusual circumstance where our next meeting is more than 30 days out, and if he only gets 3 votes or less than 4 votes, it's in fact just total, rejection, given that we're not meeting again. And I'm not sure if we would ask him if he wants to defer or where this is going.
I was about to have a bad idea, but my bad idea was going to be, because the neighbors don't have a problem with the orientation. We don't have a problem with the orientation. It hits all the requirements for the variance and the setback. The condition could be that prior to building, you do a traffic study, get the impression of what is the best way to go in and out. Because I agree with the neighbors, taking a left it's got to be a backup. It just has to be. I'm just a lawyer, but I'm wondering if the condition could be do a traffic study and what it suggests for traffic in and out, he does.
I don't have any problem with the orientation. As you know, we talked about the interstate barriers there, and I'm not one to think that every neighborhood needs buildings to the sidewalk.
I'm impressed that you recognize bad ideas before you act on them. I usually find out after I've acted on that it was a bad idea. I didn't think that was such a bad idea.
I personally don't see what a traffic study is going to tell that is not apparent in my mind there already. I think the key is going to be, like all businesses, if you don't make it easy for people to get in and get out, I don't care what you got there, they're not coming to it, you know?
Well, that's why Chris suggested the architects come up with something.
But there's a difference in architects and civil engineers too, you know? So.
And
But
what I get paid at this job is way less than what I get paid to be an architect.
I think it's a solvable problem. And I think to make it solvable, you almost need to have the variance there. So I would be in favor of the variance and let him hire or employ a good thinking civil engineer or whomever of how do we best get into this site, you know?
And traffic gets a whack at this, right, Joey?
Yes, sir. Works is going to have to approve ultimately.
Yeah,
And so far they take no exception, which is a unique position.
Yeah, I think Chris correctly said that none of us apparently are against the variance as far as the setback. It's just how you get in and out of this and what's the traffic going to look like.
In fact, I think the project will improve the neighborhood quite a bit. I mean, well, so what I'm hearing is let's encourage him to hire a good civil engineer to figure out the best way in and out, and almost the free market will determine the best way in and out, as opposed to us saying, get a traffic study done and do what they say.
We could actually make that a condition because we want to prove that he hire a competent civil engineer company to do that portion.
And
We should probably say license rather than competent.
license, yes.
And I would note for the benefit of the board, with Public Works getting a bite at the apple in terms of the effect of the traffic, the appropriateness of the curb cuts, et cetera, you've got civil engineers over there. Metro employs a pretty talented gaggle of those folks who will get a crack at this. I don't say that to talk you into or out of a position, but just as a reminder, those folks are the very ones who will get a look at this.
But as far as this case is concerned, could they say no and he doesn't get to build it if they don't like whatever he has submitted? Could Public Works hold it?
They being Public Works, you
Yes.
mean? I think they're going to have to sign off on something at the end of the day. This is just about zoning before you today.
But potentially, if they, in their professional opinion, had a problem with this as it relates to traffic, would they and could they hold this up and based on a better design of it?
But there's an appeal to that as well, correct?
Sure, there's appeal to everything.
So everybody gets their due process.
There's appeal to us. You can go to court.
Okay, it's just my 2 cents, but I agree that I don't have a problem with the variance. But I also am kind of uncomfortable putting a requirement that he get a civil engineer. I do feel like we have that available to us already. And I just think that's a little bit burdensome in this situation when somebody's going to look at it and when it already exists. I mean,
Well, I don't have a problem with suggesting or making a condition that a traffic study be done. I mean, he'll have to hire a civil engineer anyway.
I always ask Chris our council stories, and I'll ask another one. The council person didn't show up to the public hearing, and neither did anyone else. Would this be helpful if the people that were here in opposition and the applicant and the council person got together as they discussed what would go in front of Public Works?
I'm always for council people facilitating, but I'm not sure we have the power to dragoon him in here and make him do it. Yes, I would encourage the council person to facilitate from this point forward. To try. Yes, yeah, I would. But I'm going to make a motion now that we've all confirmed I had a bad idea. I'm going to make a motion that we prove the special exceptions along Austin and Peachtree because it meets all the requirements of MCL 17.12.035D. And I'm also, as part of that motion, that we approve the variance along Nolensville Road because Nolensville Road and the interstate and 440 all just makes up for one giant hardship, and you've got the odd shape of the lot. And we're just going to encourage the landowner to work with Public Works and his neighbors to make the best entrance and exit possible. So we got a motion?
Very good motion. I'll second it.
Okay. Got a motion, got a second. All in favor? Any opposed? Passes.
Okay. Motion is granted on a vote of 5-0, and with that, the Board of Zoning Appeals is adjourned. Thank you.